Merrick Garland could be arrested by the House Sergeant-at-Arms as soon as this week. Representative Ana Paulina Luna went door-to-door in Congress this morning and hand-delivered a letter to every Republican colleague. She is forcing a new vote on Merrick Garland. This one is to hold him in inherent contempt of Congress. Now, Garland has already been held in contempt of Congress, but inherent contempt is different. You see, when someone is held in contempt of Congress, it's the DOJ's responsibility to decide whether or not to pursue criminal charges. Well, because Merrick Garland is the Attorney General, the DOJ has already announced that it won't be prosecuting Garland.
Hello, everyone. I'm Lindsay Reiser. The Justice Department will not prosecute Attorney General Merrick Garland for contempt of Congress. The DOJ sent a letter to House Speaker Mike Johnson explaining the decision. It follows the passage of the contempt resolution in the House earlier this week.
Just as a side note, Steve Bannon, President Trump's former chief strategist, was sentenced to 4 months in prison for this exact same thing, contempt of Congress. So when you hear conservatives complaining about a double standard or 2 tiers of justice, this is what we're talking about. And since the DOJ has decided not to do anything about those contempt of Congress charges against Merrick Garland, Representative Luna has taken matters into her own hands by forcing a vote on inherent contempt of Congress. The difference here is that if this passes, then the House Sergeant-at-Arms will have the authority to arrest Garland on behalf of Congress. Fox News even previewed this exact scenario immediately after the initial vote.
Congresswoman Ana Paulina Luna of Florida is vowing to force a vote on an inherent contempt. This is different from what we just saw happen on the House floor. Inherent contempt basically means that if it passes, it would direct the House Sergeant-at-Arms then to go and arrest Merrick Garland. So essentially, the House would be doing the job of the Justice Department. We don't know if it's going to happen. She's certainly vowing to at least use a privilege motion to force this. And if she does that, then in the matter of 2 legislative days, the Speaker of the House would have to bring that to the floor for a vote. So if that happens, this drama goes on with A.G. Garland.
And just last week, Representative Luna appeared on Fox Business to preview the vote that she is going to force on the House floor this week.
Several months ago, I introduced a resolution for something called inherent contempt of Congress. So this is something that Congress has the authority to do, and it hasn't been done since the early 1900s. And essentially what that does is I anticipated that the Department of Justice would not do their job. And so I had this really teed up and ready to go. I've brought this to Speaker Johnson's attention. And what that allows Congress to do is really be the punitive arm and really hold Garland accountable by using the Sergeant-at-Arms to essentially go and get him as well as the tapes, bring him to the wall of the House, and really be a check and balance on the Department of Justice.
So just how serious is this? Well, apparently Merrick Garland is taking this seriously enough that he's personally calling Republican members of Congress. According to Representative Luna, Garland is now calling Republican members of Congress, pressuring them to not vote for inherent contempt. This is the definition of corruption. He thinks he is above the law and can tell members of Congress what to do. You see, Garland knows that if he's held in inherent contempt of Congress, then he could be arrested as soon as this week, and potentially thrown into prison like Steve Bannon. Now, I was able to get my hands on Representative Luna's letter to her colleagues, but before I read that to you, here are my thoughts on the whole situation. I approve this 100%. This is not lawfare. This is not vengeance or revenge. This is simply holding the powerful to account. This is holding the establishment to their own standards, their own rules, their own game. The only way this persecution of conservatives is going to stop is if there's actually equal justice and equal protection under the law. Look, Steve Bannon is the perfect example of this. He got contempt of Congress charges, and it's straight to prison for him. But Merrick Garland gets the exact same charge, and the DOJ turns a blind eye? How is that fair? And of course, this doesn't even include all the ridiculous charges against President Trump, which, by the way, even Judge Judy came out and said are ridiculous.
I would be happier, as someone who owns property in Manhattan, if the district attorney of New York County would take care of criminals who are making it impossible for citizens to walk in the streets and use the subway, to use his efforts to keep those people off the street, than to spend $5 million or $10 million of taxpayers' money trying Donald Trump on this nonsense. That's my view. And that is a view that's shared by a lot of people, but they won't say it to you publicly because they'll say, oh, she must be a Trumpster. That's not true.
So what do you think? Congress has already held Merrick Garland in contempt of Congress. Do you think they'll take the next step and hold him in inherent contempt, or are Representative Luna's efforts futile? Be sure to let me know your thoughts in the comments below. Now, for those of you that are interested, I'm going to show you Representative Luna's letter, which outlines her plan, as well as the legal theory behind the move. But first, if you haven't already, please be sure to hit that like button. I know it's a simple thing to ask, but it really does help me reach more viewers like you. And if you enjoyed, please be sure to subscribe. So the letter reads as follows. Dear colleague, the Department of Justice's blatant disregard for Congress as an institution, exemplified by its refusal to prosecute Attorney General Merrick Garland, is a direct threat to this legislative body. Attorney General Garland's defiance of 2 lawful subpoenas is a clear violation of our authority. This is why, earlier this month, this body voted to hold him in criminal contempt of Congress. However, on June 14, 2024, the Department of Justice informed Speaker Mike Johnson that they would not uphold the law and prosecute the Attorney General for contempt of Congress. While that response was expected, it set a dangerous precedent. The executive branch will continue to withhold information from Congress if there are no consequences for their actions. It is imperative that Congress uses its inherent contempt powers and instructs the Sergeant-at-Arms to bring Attorney General Garland to the House for questioning and compel him to produce the requested evidence. For Congress to legislate effectively, we must have access to the information that will enable us to make informed decisions. When Congress is denied this crucial information, we are left to navigate complex issues in the dark. That is why the Supreme Court has long recognized that Congress has the power to compel information from witnesses. This power is not a mere formality, but a vital tool for us to carry out our legislative responsibilities. It is not enough to issue a subpoena, we must also have the power to enforce it. The Supreme Court has upheld that the power of Congress to conduct investigations is inherent in the legislative process. That power is broad. It encompasses inquiries concerning the administration of existing laws as well as proposed or possibly needed statutes. This power is not only broad, but also crucial for effective legislation. Equally vital is Congress's ability to enforce its request for information, a power that must not be undermined. It is this power that ensures our role in the legislative process and makes us integral to the functioning of our republic. When an individual refuses to comply with Congress's request for information, Congress is left with 3 options. We can proceed with criminal, civil, or inherent contempt. However, both criminal and civil contempt rely on the other branches for enforcement, a situation that would have been unimaginable to our founding fathers. They never envisioned a scenario where the legislative branch would be subordinate to the other branches. Yet, this is the reality when the House resorts to civil or criminal contempt. We are then at the mercy of the other branches, which can significantly impede our ability to carry out our legislative duties effectively. This reliance on the other branches not only undermines the separation of powers, but also puts the integrity and effectiveness of our legislative process at risk. Inherent contempt is a process that allows Congress to rely on its constitutional authority to hold an individual accountable for refusing to comply with congressional demands. This is a broad power that the courts have recognized as necessary for Congress to fulfill its legislative functions. Under inherent contempt, the individual is brought before the bar of the House by the Sergeant-at-Arms, tried by the body, and can then be detained in the Capitol or in D.C. This process demonstrates the seriousness with which Congress views non-compliance and the potential consequences for those who refuse to cooperate. The power of inherent contempt, first utilized by Congress in 1795, has a rich tradition in the American and British systems. Furthermore, the Supreme Court has consistently recognized the vital importance of Congress having the power to enforce its own requests for information. In Anderson v. Dunn, the court stated that without the power of contempt, the House would be exposed to every indignity and interruption that rudeness, caprice, or even conspiracy may meditate against it. In McGrain v. Dougherty, the court held that both the power to investigate and the power to enforce the request for information was an essential and appropriate auxiliary to the legislative function. This power, deeply rooted in history and law, is crucial to the legislative function, and Congress must utilize it to ensure that the executive branch officials comply with Congress's demands. The Department of Justice and the Attorney General cannot be the ultimate deciders of whether or not a congressional subpoena is enforced. If Congress allows this to happen, we risk being subordinated to the Attorney General and being completely neutered in our ability to legislate. Why would anyone from the executive branch comply with our demands for information if the enforcement of those demands relies on the actions of another department in its own branch? Congress must never rely on the actions of the other branches. To do so would betray the Constitution and take us down a road where Congress is a subordinate of the executive branch. Nor can Congress rely on the courts to enforce its subpoenas. This takes too much time and, just as with the executive, requires Congress to rely on another branch. We must remain vigilant and assert our authority to ensure the balance of power in our republic. The only option to ensure compliance with our subpoena is to use our constitutional authority of inherent contempt. In the next few days, I will call up my resolution holding Attorney General Merrick Garland in inherent contempt of Congress, and I look forward to each of you voting in favor of it. The urgency of this situation cannot be overstated. Our ability to legislate effectively and fulfill our constitutional duties is at stake. We must act now to protect the integrity and independence of the legislative branch. Go Representative Luna! If you haven't already, be sure to smash that subscribe button and to check out one of these videos.